Let me thank Dave and Rob Musser and Security Title for inviting me here today. My topic is legal claims. I'm going to talk about the title insurance process a little bit and how claims happen inside that process. Talk about what we do when we get a claim. We're going to take a look at the agency contract, or at least some parts of it. And we're going to look at the parts of the standard title policy as well. We're going to see how those policy provisions and the contract provisions affect what the title company does when it does get a claim. We're also going to look at the duties of the insureds who are involved in these cases, and that's whether they're the mortgage holder or the owner of the property. I'm going to review some law with you, some legal theories, some claims or defenses that we use, hopefully to solve title issues. And then I have case examples for you. These are essentially war stories to help you see how these things all fit together. And as Dave mentioned, you as the audience and me as the speaker both get to experience something for the very first time today, and that is me giving a continuing education talk. And I'm going to do my best to keep it interesting, and hopefully I'll succeed here. As you can see on the screen, my name is Dennis Dunn, but the big question is, why should you listen to me? Well, I'm a lawyer, number one, and we're here talking about legal claims. I've been a lawyer since 1981, and I'm with this firm. Actually, I started here in law school since 1981. The firm's called Petrick & Wellman, Novico, Brown & Petroza. We're in media. We're primarily a real estate and business firm. In my practice, I do real estate transactions, both residential and commercial. I do leasing, zoning, land development, landlord-tenant. Primarily, my practice is litigation, though, which is why you see me sitting in front of you. In fact, I've been handling cases for security title since 2003. And I didn't realize it was that long until I just took a look getting ready for this thing. I primarily do civil litigation, not only in title claims, but real estate and business, landlord-tenant work, some consumer protection, and some personal injury. Now, I don't have a title agency. I don't run a title agency. I don't search titles. I'm not even an approved attorney. I go to closings, but as a lot of lawyers in the southeastern Pennsylvania area do, we rely on title agencies to conduct the closings in large part. I read title reports. I make sure we get a marked up copy of the title report at the closing. And I rely on the title agencies to check after the closing to make sure all the mortgage satisfactions and all the deeds and everything else was filed. I can't say that I know your business as well as you do, because I don't. But the reason I'm here is because it's either going to be me or someone like me that the title company calls when someone or some company makes a title claim. Or it could be me, and I've done this before, calling a title company on behalf of a property owner who suddenly discovers a mortgage company that he never heard of taking him to foreclosure. So the main reason you want to listen to me, if you need any reason to do that, other than to get the credit you're here for today, is so that you don't find yourself somewhere down the road having me sitting next to you in a courtroom, or have somebody like me sitting next to you or opposing you. If you're going to be in a courtroom, you either want to be the judge or one of the lawyers. You don't want to be one of the litigants. And that really doesn't matter how good or bad your case is. It's just very stressful and risky proposition every time that happens. Now, one question you might want to ask yourself, because I was trying to think of what questions might be pertinent to title agents and title agencies when I'm giving this talk, is why should you worry about title claims? After all, the title company, in this case security title, is the insurance company. Aren't in fact they the ones who are going to defend and pay the claim if there are any losses? And there's a two-sided answer to that. One's yes, and the typical lawyer answer is no. You got yes and no. Initially, the title company responds and defends the claim, but many times the title problems that are in the claim are the result of something that a title searcher or a title agency either did or didn't fail to do that they were supposed to do. And when that happens, the title agency or the title insurance company or the property owner or the mortgage company, as is often the case, may bring a claim against either the searcher or the agency or the approved attorney. And even if it's just the title company handling the claim, that can affect title agents greatly because the contract itself has a broad indemnification clause. And if we can put up slide number 2, I hope you can read that. You're required under the contract to indemnify the title company not only from whatever the actual loss is, but also includes legal expenses. And I just want to go over this just a little bit here with you. So the first part's pretty clear, right at the very top paragraph. It talks about everything you're going to pay for. The next 3 parts, the subsections here, A, B, and C, talk about why you would pay for them. In other words, what is it that you did or failed to do that would lead to you having to pay for those things? And you can see it covers negligence, misconduct, fraud, dishonest conduct, all those sorts of things that if you're doing things that follow your best practices and best procedures, you don't have to worry about. But the one at the bottom, C, is one that pops up from time to time that a lot of people don't realize about. And that is that if you fail to follow or violate any of the title company's rules, instructions, or manuals, and this is kind of important because I've been through the manual for security title from time to time in different cases, and it's very detailed. And if I can impart anything to you today, is that maybe take a look through that once in a while, just to make sure you're fresh and up to speed on exactly what happens in any given situation. So we get slide number 3. Where do the claims come from? When I get a title company claim, the answer to that question is usually in one of these 5 areas. And these 5 areas are the top 5 title agency responsibilities. You're either going to perform or order a title search and review the title. You're going to issue the commitment. You're going to conduct closing and transfer funds, conduct closing, file, distribute, and record all paperwork, and issue title insurance policies. If something's going to go wrong, it's generally going to be in one of these areas. And I have some examples that we'll go through a little bit later, but if we have slide 4, I can show you some of the top title insurance claim areas. Unrecorded deeds. It's amazing how often that can pop up. Mortgages or other documents. I have an example of an unrecorded mortgage. Mortgages with missing, incorrect, or insufficient legal descriptions. And just picture how that would happen. As the mortgage comes to you to prepare and finish off at the settlement table, and generally you're the one who's putting the legal description attached as an exhibit if it doesn't show up there. You can have unsatisfied mortgages. You can see where that would pop up with a situation where the title searcher would miss it or not pick up the fact that it's not satisfied. Other liens from prior owners remaining of record, recorded restrictions missed in a title search. This can greatly affect what the buyer's actually getting if all of a sudden they find out they have these restrictions and they can't do certain things they want to do on their property. You can have errors in public records. That doesn't pop up as a claim too often, but there can be errors in public records. Illegal deeds, missing heirs, forgeries, which are more prevalent than I would like to think, and even imposters, which is a different sort of forgery. The bottom line here is the list is infinite as to what can happen that can affect title to the property and lead to a title claim. Now, some of the things that you see here. No matter what you do or how careful you are, just happen. You can't stop, you can't catch them. But some of them you can catch, as long as you have policies and procedures in place with appropriate checklists. And if you follow the manual and closing instructions and follow through after closing. And the examples that we have today generally result from someone not paying attention or making assumptions without checking them. So let's go back to when you first get a referral. You know, I did put on that list that one of the 5 top duties of a title agent, but probably the top duty is to get the business, number one. But once you get it, what do you do with it? So say you have a referral or request to insure a title for a purchase or a mortgage or a refinance. You're going to need a title search. We all know that. That means you need a title searcher, and hopefully you have available to you, and you use searchers who know what they are doing, who are experienced, and very importantly, have sufficient errors and omissions insurance actively in place. Security Title has a list that you can choose from for title searchers. They know who some of them are. There are other resources available. I'm aware that there is at least one settlement software program, there may be others, that offers suggestions for title searchers inside the program itself. But the key is that you have to use searchers that you can trust. And even when you use searchers that you can trust, because everybody's human, and even the best searchers can miss something, the errors and omissions insurance coverage that the searcher has is very important. And it's important to protect you. And as you heard Dave say earlier, Security Title wants everybody here to succeed in their business. And this is one more big thing to get to protect you. Now, to do that, you don't just ask them, do you have errors and omissions insurance coverage? You get them to provide a certificate of insurance or a paid up declaration page. You look at it, you make sure that it's current, you make sure the policy limits are big enough to cover the transactions that you're handling. So after you get the title searcher's results, as we all know, the results go into the title commitment. They go in either as exceptions or requirements, and this is a process all of you do every day. The one thing you need to do is to make sure that the exceptions are clear and complete, so you're not providing coverage for something you did not intend. So if we could see slide 5. Now, I took this out of the Security Title Manual. It's section 5 of the manual, and it talks about exceptions and requirements language. I just want to highlight a couple sections here. The very first sentence says that the policy and the commitment, subject to its printed terms and conditions, insures against every defect or encumbrance not specifically accepted. So this is kind of critical. What that means is that you're going to cover, and the policy is going to cover, whatever is not listed as an exception. And it's second nature to most of you that, you just got to make sure you fill in the exceptions, but the overriding principle starts with everything's covered that's not accepted. So keep that in mind as you do it. And then you have to make sure that the exceptions are clearly worded. And in this section 5, you can see where it says there is no prescribed language for any exception. However, each exception should be worded so its meaning is clear. And you should be as specific as possible in the language used so there is no question as to the matters being accepted. The good part of this is that the manual itself, if you don't have the language already set aside in what you keep in your office by way of checklist or standard exceptions and things like that, the manual itself contains suggestions for those situations. I don't have a feel for whether or not the language and title commitments is a big problem. I don't usually get called in to handle coverage questions. But I do know that I have a case right now, as a matter of fact, where the problem wasn't necessarily the exceptions, the problem was the legal description. And it sort of highlights exactly how careful you have to be in putting these things together. So the agreement of sale came in and it listed the property, and the property had a deed that had 3 parcels on it. But the intent of the parties was only to convey one of those parcels, and they thought it was subdivided. Well, everybody knew they only intended to convey 1 parcel, but the deed that was deeded out from the buyer to the seller included all 3, and the title policy and the legal description included all 3. And even though the buyer was completely aware that he was only buying 1 parcel, he wasn't paying for the other 2, that doesn't stop him, it didn't stop him from trying to get title insurance recovery and make a title insurance claim because of this mistake. And it's a complicated litigation, but the bottom line is it is an example of what's called a mutual mistake. And it's an example of how you just can't take anything for granted when it walks in the door. The cases I get to handle most of the time either involve flat out fraud. I've got a couple examples of those, or something that a searcher or a title agent missed entirely. Now at this point, we're going to do poll question number 1.
Thanks, Dennis. I'm going to go ahead and launch the first poll question here. What is the most important qualification for a title searcher? We'll give the audience a few moments here to respond. It looks like we already have 75% of the respondents here, so that's great. Everyone is fully engaged or highly opinionated. I think that's typically when we get a lot of quick responses, that's what it is. Alrighty, I'm going to go ahead and close out the poll because we're at almost 100% here. And I'll share with everyone the results. It looks like the majority at 66% responded C, sufficient errors and omissions coverage. And a third at 34% wrote A, thoroughness.
Okay, well, the bottom line is all those qualifications are critical with a title searcher. They have to be thorough, they have to be diligent. But to protect you in situations where things just happen, you want to make sure they have enough coverage. That's about the only thing you can control when you go to pick a title searcher out. And my suggestion is make sure that they've got enough coverage so that if you find yourself in a bad situation somewhere down the road and you're talking to me or somebody like me, you've got the title searcher, if that was where the problem was, with enough coverage to take care of everything to keep your agency protected. Now, what happens when we get a claim? And assuming coverage, we next check to see whether or not the claim is valid. In other words, is there really a title problem? And if there is a title problem, we're not here just to write checks to cover what might be a title problem. First thing we try to do is fix the problem. And we have slide 8 up here right now. And you can see in looking at slide 8, and this comes from the standard title insurance policy, that the company has the right to basically do whatever it needs to do in order to establish the title to the estate or interest as insured, or to prevent or reduce loss or damage to the insured. And that's the key language in this thing is we have the right as the title company to take whatever steps we need to make sure that you get, as the policyholder or the homeowner or the mortgage company, the title that was called for in the title policy. This provision and the way we do this is actually good both for the policyholder and for the title company. For the policyholder, the one thing about title insurance is it can go on for a very long time. And it could be that, the house that somebody bought, for $250,000 10 years ago might be worth $800,000 today. And the title policy, if they have a problem, wouldn't really give them the settlement that they need in order to cut their losses. So having the right in the hands of the title company to try to fix the problem is very important for the policyholder in order to preserve the value of what they really have at that point in time. For the title company, it gives us a chance to make things right, and it can also save us a significant payout. Now, how do we fix it? Well, what I like to do, and what I work with Rob Musser a lot doing this, we ask if we knew ahead of time, in other words, before this policy was issued, about this problem, what would we do to clear it up? And is that solution still available to us? So if we knew ahead of time, the first thing that would happen and this is the kind of thing that pops up when you're trying to just go through a settlement. You've got a problem on the title. How do you fix it? You call up the people who have the adverse claim. You get hold of them. You get hold of their lawyer. And you try to see what you can get them to sign, if there is something you can get them to sign, whether it's a deed or a quitclaim deed or a mortgage or judgment release, something like that. If you have an adverse possession claim, get somebody to sign something you can record acknowledging that they don't have those rights. If you need to extinguish an easement, whatever the piece of paper it is, you try to get it to reduce the loss that you're going to have. And again, this brings us back to that phrase inside this section B I pointed out to you, where you're trying to, as a title company, establish the title to the estate or interest as insured. Now, there are cases, and thank heavens there are a fair number of them, where people are simply willing to sign what's needed to solve the problem. There are other cases where people need to be persuaded a little bit more. Sometimes it takes legal arguments, sometimes it takes threats of litigation or something like that to make it work. Sometimes the people have a valid claim and they need to be paid. And we've done that in the past. And when we do that, we may take an assignment of their rights. Or we might just pursue the rights on our own by way of what's called subrogation. And subrogation means we stand in the shoes of the person who we paid off. And we can pursue those rights to reimburse the loss that we suffered. And I have an example of that when we get to them. Now, what if we can't work this out by agreement? Well, in that case, we're probably headed to court. And the law has some powerful remedies. And the one thing that I've noticed when we go to court is it tends to focus everybody's attention on what's really important and what needs to be done, because you have the impending decision by a court somewhere down the road that you can hold over everybody's head and hopefully get them to see things a little bit more reasonably. One of the go-to remedies in title disputes is an action to quiet title. And the lawyers who are here know exactly what that is. It's a very versatile remedy. It's simply a lawsuit asking the court to determine who has the title or who has whatever right it is that's in question. And it's governed by the Pennsylvania Rules of Civil Procedure as to exactly what you can do inside an action to quiet title, and it's Rule 1061 and following. So if we can, we have that slide up, good. So the purpose of the action to quiet title is to unify into a single procedure many of what used to be a bunch of miscellaneous procedures that were used to try clouds on title. And the reason I'm putting this up here is so that all of you can see just how broad it can be. So you can compel an adverse party to commence an action in ejectment. You can have any right, lien, or title or interest on the land determined. You can determine the validity of any document or obligation, things like that. And it pops up for a lot of instances where you just can't, well, let me put it this way. When you do a lawsuit, sometimes there are a lot of alternate claims. And this allows us to put them all into one lawsuit and have them all decided at one time. Now, I showed you before the standard policy provision that allows the title company to do what it deems necessary to solve title problems. There's another provision in the title policy, if we go to slide 10, which expands on this right. Yeah, slide 10. And it gets more specific. It spells out the duties of the insured, and it also allows the title company to stand in the shoes of the policyholder to do what needs to be done in court. It's a little bit different than the one I sent you before. The one I sent you before sort of just says what the title company can do. This one talks about what the insured has to do and how they have to cooperate. And they have to, it says here, give all reasonable aid in any action or proceeding, securing evidence. In other words, we get to see whatever documents they have. They got to help us find witnesses. They basically just have to cooperate. And if we work out a settlement, then they agree under the policy that as long as we have a reasonable settlement for them to work with, they will go along with that, because usually we need their cooperation and their signature in order to get something going. Now, one thing that pops up in settling some of these title disputes, and in any lawsuit for that matter, is what I call service of process issues. And whether I use an action to quiet title or some other legal remedy, no matter what it is, if you're suing somebody, you have to serve them with process. That is, you have to give them legal notice that they're being sued. If we're on the defense of a case, that doesn't matter because we're the ones being sued. We've already been served with process. But if we have to bring some sort of claim in order to get rid of something that's messing up the title, what we often find is that some people are long gone. Dead. Oh, that's not my phone, is it? Okay. So there's a process for that. And I just want to go over this a little bit for the lawyers who are involved. And I also want to go over it a little bit for the title agents, just to know that, just so you know that when you see something that pops up as a title issue and the party that you need to get to sign something or you need to have rights discharged against, it's not always a lost cause just because they're gone or missing. But the law requires that we give them legal notice. That doesn't always mean that they get served personally with a piece of paper. And the process is that we go to court, first we file the action that we're going to file, asking the court to do what we want it to do. And then we try to find out where these people last lived, and we go serve them there, and then it comes back, they haven't been served, or we can't find an address on them. But whatever gets us to this point, we try to make what's called substituted service. And that's governed by Rule 430 of the Rules of Procedure for the lawyers. And basically that means that you need to tell the court with an affidavit about the nature and extent of the investigation that you made to determine the whereabouts of the defendant. And you have to explain the reasons why service can't be made. The one drawback with the rule itself is it doesn't say what's good enough. And your success in getting a court to allow you to do substituted service, and substituted service is usually going to be publication in a newspaper and posting of the property that's involved in the title dispute. But your success very often is going to depend upon the view of the judge reviewing the motion. The only thing the case law says is that you need to make a good faith effort to discover the correct address, and different judges have different views of what that is. Fortunately, there is a note that follows Rule 430 that sets out an illustration of what a good faith effort would include. So you can go to the postal authorities with a Freedom of Information Act request, and you'll get those results. And they may or may not help you, but the results, having the results helps you because at least you have something to show the judge that, well, they can't find him either, judge. You find out whether or not there are any relatives or neighbors or friends or co-employees of the defendant. You ask them questions. You look at telephone directories, you do a Google search, you do an internet search. I have a service, I have access to a service called AccuRent, which we use to help find people. And you could even go as far as hiring a private investigator. And as involved as this is, and it can get involved, you've got to go through the process to set out for a judge what's going to keep the judge happy to sign the order that says, yes, you can go ahead and do substituted service. And what you find out at the end of all that, when you get that order, is I'm glad I did that. I'm glad it was something that I did because it's worth the effort. Because once I get the order and once I make the service, the fact that it was so hard to find that person makes it unlikely they're going to respond at all. And that's going to get you to the point where you can get a default judgment. And once you get the default judgment, and this process should take less than 6 months, hopefully less than 4 months, you can get the title cleared up and you don't end up in a long drawn out battle for that situation. There's another tool in our toolbox that we have of procedures that we can follow in clearing up titles. And it's a procedure called a lis pendens. Now, a lis pendens is a separate document that goes with part of a regular lawsuit. So it's not a separate lawsuit. You can't do a lis pendens unless you have a lawsuit involving title to real estate. And all lis pendens means is that this lawsuit is notice to the world that the pending suit involves title to real estate. And how that helps you if you're representing somebody who wants to, to have the court declare they've got an interest in the property that you're going against. If the person who owns that property attempts to sell it while the suit is pending, and you have the lis pendens filed, the buyer, whoever that buyer might be that's buying it, is on notice because the lis pendens shows up in a title search, and it will show that somebody else is claiming title, and the buyer at that point can decide whether or not to go through with buying it. But if they do go through with it, they're stuck with whatever the results of the lawsuit are. So, as a lawyer, if you're the person filing the action to quiet title or any action that involves title to real estate, such as an equity action to reform a deed or mortgage, you've got to consider filing a lis pendens as part of that lawsuit in order to protect your client's interest. The one thing you have to make sure, though, is that the lawsuit that you're filing actually does involve title to real estate. If it doesn't involve title to real estate, then not only will the lis pendens be knocked out, and that's not the end of the world because you weren't entitled to it in the first place, but you can also find yourself on the hook for damages caused by clouding title by filing an improper lis pendens. Now, one example of that was a case from the Superior Court, and if anybody needs the cite for this, just send me a message in the chat here. It's called Saki versus Ferrari. So in this case, the initial lawsuit was a guy trying to collect money. Pretty straightforward. Before he actually got his judgment, so before the lawsuit was over, the guy he was suing, the debtor, transferred his property to a third party. Now, obviously, what the debtor was trying to do was to protect that asset from being subject to the judgment lien, being subject to collection. He got it out of his name into somebody else's name. So after the creditor got his judgment, he said, okay, now I've got a judgment, and he's got to give me back that property that he fraudulently transferred. So what he did was he filed a suit for the fraudulent transfer. Well, actually, he didn't file a suit for fraudulent. What he did was he just put a lis pendens on the property. And what the Superior Court said was, no, you have to file a suit for a fraudulent transfer and get your judgment first before you can put any lien on that other property. And the fact that you put the lis pendens on the property when it was in the hands of the third party was improper. And you got to pay that third party's lawyer's fees and court costs and whatever damages were caused to him by having a cloud on title. So it's a pretty risky thing if you get it wrong, but if you get it right, you are going to protect your client. Now you have in front of you the precipice for the list pendants. And it's really a simple form. You just fill it out, you put in the address, the folio number, and a legal description gets attached. But the key here is make sure that you've got title to real property involved. Now, at this point, I'm going to switch from the processes and procedures that we use to substantive rights. And the overriding question here, and we all know the answer to this, is what is it that says you own property, that you have a legal title to it, or that you have a mortgage on it, or you have an easement on it? The answer to that is that you have a deed from the prior owner, right? Or you've got a mortgage from the legal owner, or you have an easement. And you heard, if you're in this morning's session, you heard Rob Musser talk about the process from before recording statutes and things like that with the livery of season. It took me back about 40 years to law school. And actually, I'd totally forgotten all about that. But before recording statutes, that was it. You got the deed, you owned it. And the recording statutes are the primary reason, as we all know, that title insurance can exist in the first place. Without those statutes, title insurance would make no sense. Because under the common law, once somebody deeded their property to someone else, they no longer had legal title. And if they wrote a second deed, the second deed was worthless. So if someone was knocking on your door before the recording statutes with a prior deed in their hand claiming ownership, that person would have those rights as long as it was a valid deed, because there was no recording statute to protect you. Now, the recording statutes say that if the person who's knocking at your door did not record their deed or their easement or whatever other written instrument it is they have, the document they did not record is deemed to be fraudulent and void as to any subsequent bona fide purchaser or mortgagee. And that's the key phrase there. It's got to be subsequent, it's got to be bona fide purchaser or mortgagee. As long as the bona fide purchaser does not have actual or constructive notice of the adverse claim and paid value. So what is constructive notice? Well, if it's on record, it's constructive notice. That's pretty simple. You don't have to go search the records yourself to see what's there to be charged with what the knowledge is that you would have if you had looked there in the first place. And that's basically the premise for title insurance, is that the title companies in providing the insurance rely upon the fact that the recording statutes protect their customers and hence them from these unrecorded deeds or easements and things like that. Now, there's also another type of knowledge that a purchaser can have, and actually there's two types that is available even if it's not on record. The first one is information that they could have learned if they had inquired of persons in possession. So that means that they're charged with knowledge of what they would have learned if they went to the property and asked people about, why are you here? Why do you have possession here? And it seems sort of silly to say that, but the good news is in most real estate transactions, people inspect the property somehow or the other, they see it before they buy it. But they're charged with that knowledge to find out what they would have learned if they'd asked the people who were there at the time. Usually it's the owner, obviously, unless there's some type of fraud going on, but that's one type of knowledge that they can have. The second type of knowledge that they're charged with is what information they could have learned if they had inquired of others that the purchaser reasonably believes knows of facts which might affect title. And I'm reading that, and I've read it over many times, and I'm not so sure I still know what that means. I don't know how a purchaser would know to ask anybody facts that the purchaser doesn't know about. I just don't know how they would do that. I'm sure there are cases that talk about it and that have applied it. I haven't seen them yet, but my assumption is that you would have to get the purchaser, who obviously is not inclined to do so, to admit that they knew of the adverse interest, or to state that they were aware of the adverse interest from some other party who was not in possession. Or you'd have to have some other type of compelling evidence. I just couldn't think of a good example of where that would come up. Now, another substantive way to get legal title, you don't need to have a deed to get legal title. Another way to do it is called adverse possession, and I'm sure all of us have heard of that. The claim for adverse possession, if it's available, fits perfectly under an action to quiet title. It allows someone in possession of the property to claim ownership, and they have to meet all the requirements for a period of 21 years. And here are the requirements. They have to establish actual possession, which the law calls dominion over the land. It doesn't necessarily mean they have to occupy the property. There are all sorts of ways to claim dominion over the land without being in occupancy, because some lands aren't actually occupied. The possession has to be continuous, and that's very often the source of a lot of litigation. How continuous was it? Because it has to be 21 years continuous. It has to be visible and notorious, and that sort of goes hand in hand with continuous, because people have to be able to know when they look at the property during that 21 years that it is being claimed by someone who's not the real owner. It also has to be exclusive. You can't be sharing it with somebody else. And it has to be hostile. And not hostile in the sense of being mean, but hostile in the sense of against the interest of the record owner. So perfectly nice people can go sit in your backyard and put a fence up around it. And if they stay there long enough and build a house there after 21 years, they could make a claim for adverse possession. Now, one of the keys for adverse possession is that every one of those requirements have to be met. In my experience, courts don't like adverse possession because it messes up what's otherwise record title. And you've also got problems that pop up, and I haven't seen a whole lot of case law on this yet. What happens if somebody claims they own a portion of your property, but it hasn't been subdivided? Because how can you adversely possess something that hasn't been legally subdivided off? And I'm waiting to see how that pans out as we go along. One of the limits of adverse possession is that you cannot make an adverse possession claim against the federal government. You can't make one against the Commonwealth of Pennsylvania. And you can't make a claim for adverse possession against a local government in Pennsylvania if the land is devoted to public use or is being held for a tax sale. And I've seen this one pop up a couple times where somebody made an adverse possession claim against a municipality, and the municipality said, well, we're the government, you can't make a claim against us. And the answer was, well, they can, because you're using that as, say, a golf course or something like that. You know, it's something that is really not part of your public use. Now, generally, and obviously, adverse possession won't show up in a title search. If you have a survey, it may show up on there. And if someone does claim adverse possession and you're trying to get a clear title, the person who owns the property can bring a claim for an action in ejectment. And this claim simply means we're going to put you off the property. In order to do that, the person you're trying to put off actually has to be in possession of the property. And the person who wants to get them put off has to, number one, be the owner, number two, not in possession. And this is a good type of procedure to use when there is a potential adverse possession claim, but it's not yet 21 years old. And actually, you can bring it whenever you want, but if it's after 21 years, then you're having a battle over whether it was continuous, whether it was hostile, whether it was open and obvious and all that sort of stuff that we went through with all the requirements. Now, what if after you go through the settlement, you find that the paperwork is wrong, or that there's a deed or mortgage that has wrong names on it or incorrect legal description? How do we fix that? Well, we do a request to the court for reformation. And when we do that, we usually bring, at least when I do it, I bring an equity action, and I've had it done. I've seen it done either an equity action or an action to quiet title. But the remedy itself is based upon equitable principles. And the remedy is based also upon some type of mistake. It can be either a mutual mistake or a unilateral mistake. Once you bring the claim, you've got to meet the burden of proof for a mistake. So the burden of proof to reform a document is different than the burden of proof in most cases. And most people are familiar with, beyond a reasonable doubt that applies to criminal cases. For those who are familiar with civil cases, the burden of proof is by preponderance of the evidence, which is just a 50-50 scale. But for certain types of claims, including reformation, you have to have testimony that is clear, precise, and indubitable. And that's higher than the balancing scales, but it's not quite as high as the beyond a reasonable doubt testimony. For a mutual mistake, it has to show that both sides, your testimony has to show that both sides knew they were making a mistake. This isn't what they intended. If it's a unilateral mistake, number one, you have to show that you, the one who's trying to get it reformed, was a mistake. And the number two is, even though the other party didn't make the mistake, that party has enough knowledge of the information or of the mistake to justify an inference of fraud or bad faith. And that is a very heavy burden, very heavy burden. At this point, how about we do poll question number 2?
That sounds great, Dennis. I'll go ahead and switch over to the poll questions. And I will go ahead and launch that now. For responses here. And the question is, what is the statute of limitations for adverse possession? Is it A, 10 years, B, 5 years, or C, 21 years? We'll give a few moments for our audience to respond. It looks like we almost have everybody here. We have about 96% voting in. So feel free to get your last minute responses in now before I close out. All righty. I'm going to go ahead and close out the poll, and I'll share with you the results. It looks like an overwhelming majority at 95% answered C, 21 years.
Good, and that's the correct answer. All right, so I'm going to skip through the part I did about depositions, except to say one thing. That is, there's only one rule in a deposition, and that is you have to tell the truth no matter what. Everybody knows that no matter what. But make sure if you're called in to do a deposition, and believe me, if you are called in to do a deposition, that means the documentation is not what you wanted it to be. Because in a action to quiet title or a reformation case, you only get to depositions if there's things that are unclear in the documentation itself or some type of fraud involved. But you've got to listen to the questions carefully. You got to make sure you understand what's going on, and make sure you listen to the lawyer's instructions who's going to advise you, and be familiar with the facts of the case that you know of before you get deposed. You don't want to be sitting there giving a bunch of, I mean, obviously, if your correct answer and true answer is I don't know, that's one thing. But if you really don't know a whole lot of stuff that you're supposed to know because you didn't look at all the documents or prepare correctly for them, that's not going to bear well with you as the case moves on. So I'm going to get into case examples now. And here's the first case I have for you. I've got about 4 or 5 of these things. And let's see. Actually, this is, can I do a blank screen here? Because this is not the first case. I don't have a slide for this first case.
Oh,
blank slide or not. That's the second one I'm going to cover.
All right. I don't have a blank slide in the deck, but I can.
All right, well, leave that there. I'll get to that when I get to it. But that's the next one I'm going to talk about. So the first example I don't have a slide for, but it's a forgery case, and the record in the case did not leave much of a clue. And the more I looked at the case, and even today, many years later, looking back in the case, I'm convinced that part of the problem was a fraudulent notary in this case. So what happened here was the mother died. She had a bunch of children, and she left the property to her kids as co-tenants. And one of the children, one of the daughters, and I call her the thief for the purposes of this talk here, prepared a deed from her siblings to her. So she was going to take the property from her siblings. And then the allegation was, and I believe this is true, that she forged their signatures. But all the signatures were notarized. And the only thing that showed up on record at that point when that deed got recorded that was of note to me was that that particular deed was not insured. And I don't know what security titles policies are or your title agent's policies are for when you see transactions on record that aren't insured, but based upon my experience, that's a red flag that you want to go back and relook at that transaction to see what happened. So after taking title, the thief took out a mortgage on the property. And it sounds like some of the things you hear about on the radio and TV where they're trying to sell you home title policies, home title lock policies, things like that. Only this was before all that happened. The mortgage itself was insured. The thief took the money from the mortgage, and then she executed and recorded another deed back to some of her siblings, as well as her and her own children. Now, eventually, as often happens in these cases, she wasn't paying the mortgage back. And the mortgage company started foreclosure proceedings. And then to make matters worse, the thief just died and left the whole mess for everybody else to figure out. So the siblings claimed that they had never signed a disputed deed. And we got it when the mortgage company came to the title company to protect its lien. We tried to get the family to refinance. That didn't work. So we ended up going to court. It turned out to be, as often happens, a complicated process. We had to get the title agency file to see how all this got where it was. And I guess the highlight here is that it's really important to keep complete files of everything that happens in the transaction, because you never know when these things are going to pop up. We had to identify all the interests involved, and there were deaths in the family and things like that. And then we needed some legal theories and to clear up, and we need to know the facts to clear up the title so the mortgage company can move forward with foreclosure. We filed an action to quiet title. We asked the court to declare that the mortgage company had a mortgage over everybody else's claimed interest. Now, our primary theory as we got into this case, and this was because the deed was notarized, was that the siblings actually signed the deed, meaning that the thief wasn't really a thief according to what we thought when we got started here, and also meaning the mortgage was valid lien and the company could just go ahead and foreclose. Now, we also had a bunch of alternative claims, and under Pennsylvania law, you're allowed to assert inconsistent on alternative claims. And here it was necessary, not only because the thief was dead, and she couldn't tell us or testify that she saw her siblings sign the deed. We didn't know what the notary was going to say until after we filed suit. So the question was, did the siblings sign the deed? Well, the notary, as we all know, has a duty to assure that the people whose signatures purport to appear on a document actually executed it. And the notary is supposed to keep records of that. We took the notary's deposition. She claimed that all the signatures were valid. She said that everybody there showed up with photo IDs, that she matched the faces to the photo ID. She kept copies of all the photo IDs and made all the people present sign copies of the deed. Now that sounded great. According to her testimony, she followed the law. So then I asked her, so where are these records? Oh, we lost them in a flood. So we couldn't prove any of it. We had no positive testimony that this actually happened. And as I said before, and not to anybody's surprise, all the surviving sisters denied signing anything. And important to me in this was they denied that before that they knew the records were supposedly destroyed. Now, the one thing that convinced me that this was probably a forgery on the part of the sister, the thief, and also fraudulent notary was that there really wasn't much of a chance that this forged deed just happened to coincide with a flood that destroyed all the records. And I never understood how a flood would make records so destroyed that you couldn't read them at all. But that's what the claim was, and we didn't have any records to look at. So we determined that the signatures were likely going to be found to be forged, which meant that the notary, in our estimation, would be responsible for the loss, which would be great. But there was one big practical problem. The notary had no insurance. And as we all know, you can't get blood from a stone. So in order to resolve this case, we eventually worked out a settlement with the siblings and the other heirs who were involved there in order to get clean title to the mortgage company. We presented that as a settlement to the court in a stipulation at a hearing. Everybody was present when we did it. And the court entered an order, and the title company, Security Title, took a deed from all those people who were involved. And then we deeded it over to the mortgage company so that they could finish their mortgage foreclosure. The one thing that helped us here was all the, I shouldn't say all, but some of the alternate legal theories that we used, to negotiate with the siblings. And we used these in order to show them that they had a risk if they went to trial. And I just want to go over one of them. So you're going to get a little bit more law here. One of them is called equitable subrogation. And equitable subrogation allows a person who pays off an encumbrance to assume the same priority position as the holder of a previous encumbrance. And what happened in this case was the mortgage that the mortgage company provided was used to pay off some liens on the property. So our argument was that we got the mortgage, even if they hadn't signed the deed, even though they denied having done all that and we couldn't prove that they did it, they still were responsible for the liens that we had paid off, because that increased the value of the property. It benefited the value of the property. And I like to think that that helped us get a better settlement than we did. Actually, it wasn't too bad of a settlement when we consider what the value of the property was and the value of the mortgage. Now, for equitable subrogation, the courts require 4 elements. The claimant has to pay the creditor to protect his or her own interest. And the claimant in this case would have been the mortgage company that we were working for, representing, trying to protect their lien. The claimant did not act as a volunteer, which it did not. Obviously, it was getting paid interest to do what it did. It was not primarily liable for the debt, and certainly the mortgage company wasn't primarily liable for any of the debts that were paid off at the settlement table. And allowing subrogation will not cause injustice to the rights of others, which it would not. I mean, they got value and benefit to the property by letting that happen. All right, now I'm up to the second example that I have here. And I'm getting pretty close to my time here, aren't I?
Yeah, we're about 7 minutes away from the top of the hour.
Okay.
So I would say if you want to go through this one last one, if you want to pick one of your examples, that'd be great. I can run the last poll, and we do have a few questions.
Okay.
Adverse possession that did come through. So.
All right. Well, let me do this
Like.
one. This one has a nice backstory to it. I'll try to get through it as fast as I can. What you see here is a deed from Carmela Cimbello to herself and her son, John Anthony Cimbello. Now, Carmela had 3 sons. She had John, she had Danny, and she had Michael. And John was living with his mother, but she died a long time before I got involved in this case, and it apparently wasn't very long after she signed that deed over. But what happened was John took out a reverse mortgage, and he signed the mortgage. And as you can see here, looking at this mortgage, it's to mother and son. Under Pennsylvania law, they're presumed to be co-tenants. And actually, it says right in the first part of the deed itself, I didn't circle the part, but you see right above the second circle, it says tenants in common. So they're co-tenants, tenants in common. So when the title searcher did the title search, it came back that John had title and not that the mother had any part in the title. So there was a mistake that was done at that point by the title searcher. So John gets his title, gets his mortgage, his reverse mortgage. He lives for however many more years it was, 25, 30 years more, and then he dies. And the mortgage company wants to get paid. The mortgage company had a problem with the foreclosure, obviously, because they couldn't foreclose on the interest of what is now the mother's estate, and the mother's estate had never been probated. Now, the reason I mentioned the other two brothers is because they enter into how this thing worked out. Michael Sambello, who actually was the guy I finally finished this case off with, was a songwriter, as was Danny. And Michael wrote the song Maniac for the movie Flashdance. And whenever I would talk to Danny to try to move this thing forward, I got to hear all about their songwriting capabilities and everything else that went on. And they were characters. And as you might expect, being songwriters, they were really tough to get hold of every time we tried to get something done. So this case went on for quite a while. Luckily, in one respect, John had a son who was very cooperative with us. But we had to figure out some way to convince these two brothers to probate their mother's estate. And they had no incentive to do that because there really wasn't anything that they were going to get out of it that they could think of. Well, I worked with Danny for a while. We kept going back and forth for a long time. And we finally came up with an idea that they could, get some reasonable value out of it. And the thing that helped us out the most here was the fact that they failed to probate the estate. What that means is that the house had a certain value when the mother died, whatever it was, and it should have been declared in the inheritance tax, and then they should have paid the inheritance tax on it. But because so much time had elapsed and they hadn't done that, they were going to be on the hook, or the estate was going to be on the hook for penalties and interest. So whatever number we gave them could get eaten up with penalties and interest. So we came up with a number that actually just reimbursed them for the expenses of the funeral and things like that, and their lawyers' fees, and a little bit extra for them. It wasn't really very much at all. It was the number we did. But while we're trying to work this out, Danny wanders out of a bar in the Maniac section of Philadelphia, falls into the Schuylkill River and drowns. So now I've got two estates to deal with. Actually, now I'm up to three estates. I got the mother's estate, I got John's estate, and I got Danny's estate. And the one thing that's kind of important here is this is the sort of stuff that can happen in any lawsuit, which is why it's so important for everybody to read all the paperwork correctly so we don't get to these sort of situations. Now, eventually, we did work it out, as I said, with the settlement, and we finally got title over to the title company, or over to the mortgage company, so that they could finish the foreclosure, which was actually a big bonus for us, because I think the mortgage was something like 300,000+. The property at that point was only worth about maybe 100, 120,000. So I guess that's the limit of my presentation at this point, right?
Well, we did have one question about the scenario, and hopefully I'm reading it correctly, but the question is, how does the notary rule under statute 1715 fit into this scenario?
Well, I can tell you that I don't know what statute that is, so I don't know how it fits in.
Okay, that might be a follow-up question then I'll send to you. But yeah, we are coming up to the top of the hour. I know we had one more poll slide that we wanted to get through. Let me launch that right now for folks so we can get that squared away. And then we'll go into a few questions that people had about adverse possession. So the poll question now is, what color is Mr. Dunn's tie? Question, if you're responding A, who is Mr. Dunn? Good question. B, what tie? Or C, blue? Alrighty, we'll give a few more moments. I see about 90% of you have responded already, so that's wonderful. Alrighty, I'm going to go ahead and close out the poll. So get in your last second responses here. Alrighty, and I have closed it. And I'll share the results here. Comical, but yes, 85% of you responded with C, blue. I do believe that's the correct answer.
It is.
Alrighty, so let's switch gears. Thank you for your presentation, but let's switch gears to some questions here about adverse possession, and a number of you had asked about it. It's more so pertaining to whether or not there was recent legislation shortening the adverse possession time frame in certain circumstances. I'm not sure if you're familiar with that.
Well, I am familiar that there is a statute that allows for 10 years if you go through a certain procedure. And my understanding of it is that the procedure is such that you notify the person you're making the claim against. So hopefully if that person is around, they can actually protect themselves. I don't know the details of the procedure. I haven't been involved in a situation where we actually did it, but I do remember that part of the process is that if 10 years have gone by, then you can go ahead and file something as the person who is adversely possessing in order to try to get full title.
Thank you for that. I'm taking a look in the chat boxes just to make sure there isn't any other lingering questions, and I'll definitely follow up with you, Dennis, so you can follow up with the first question that we had regarding the notary rule. I think that may be a little bit on me, and maybe I'm not reading it correctly.
You know what, that came from me. We're running overtime on She, so we had some good questions, and I do want to let everybody know that you do not need to fill out any forms to get your credits, right? We have all your information from your registration. We have you logged on to it, answering the poll questions. So I did a couple of emails and texts. You're used to in a live situation filling out your own form. As long as you answer the poll questions and we're online, you're going to get your credits. So don't worry about that at all. Dennis, thank you so much. What a great presentation. I really, really appreciate that.